Welcome to Leveraging Inspiration, the Inspired Patent Podcast, where we help you understand and leverage your intellectual property. I'm your host, Wayne Carroll, and I'm excited to bring you insights and stories from the successes and failures of others and teach you how to win at the game of intellectual property. As always, I start with a disclaimer. This is a podcast. It is not a consultation. There's no attorney-client relationship. I'm not giving legal advice, but I am giving some great information, which is for educational and informational purposes only. So this week we have been talking about strong utility patents. We're on episode 12, and our topic right now is don't shoot your patent in the foot, avoiding admitted prior art. So did you know that if you follow the advice of the patent office, you are likely to limit your chances of approval? There's a background section that they recommend, and anything you say in your background section can and will be used against you by the patent office. The patent office recommends you include a section titled Background of the Invention. As I discussed in episode 11, we don't like to put the word invention in our patents because the invention is what's in the claims. And if you put the word invention in your patent specification, that might be used against you. Now, if it's in these section titles, that should be fine, but it's just, we just want to be safe and not even use the word invention in the patent. So the background section that they recommend includes the field of the invention or the technical field. And this is supposed to focus on the patent classification system that they have of where should this patent be classified. It's really supposed to help them to guide this patent to the right division and to the right examiners. So it's really to help the patent office. And then the second part that they recommend is putting a description of the related art, including information that you're going to put in a separate form that's not in the patent application itself, but is filed with the patent office. And they say that a description of the related art known to the applicant, they want you to put that in, and including, if applicable, references to specific related art and problems involved in the prior art, which are solved by the applicant's invention. And you can also title this background art. So if you follow this advice, you're likely to discuss what has been done before. And when you say in your patent application, this has been done before, then the patent office can and will use that against you. So let me make sure I back up and give you some of this language. I know the term prior art, if you're new to patents, you might not be familiar with that. Prior art is anything that is a publication that is prior to your patent and can be used against your patent to reject it or to show that it's not eligible for a patent. So it's called prior art. And in the patent office, art means science. It's confusing. But that's actually how the Constitution set it up. So art is science. And so prior technology is really what it should be, prior published technology, but they call it prior art. So because that's the term, I'm going to go ahead and use it. As I may have mentioned before, there's a lot of confusing terms in patent law, and prior art is one of those. It's not art, it's technology. So the specification is the next term I want to discuss, and that is the written part, the words in your patent application. And the background section is a part of the specification, part of that written part. So there is a manual of patent examining procedure. It's for the patent examiners in the patent office, and it gives them guidelines, including what they can use against you, called admitted prior art. And this is from the manual. It says, a statement by an applicant in the specification which it would include the background section, or made during prosecution. As we discussed in episode 11, anything we write to the patent office in responding to rejections and such. So, or made during prosecution, identifying the work of another as prior art is an admission which can be relied upon for both anticipation and obviousness determinations. So patents are rejected based on what's been done before, based on two ways. Either, and it's based on the claims. Is everything in this claim already been shown before in one reference, or is what's in the claim obvious based on multiple references? So they can use it either way. And if you admit that it is prior art, then they can use it. And here's the kicker. They can use it, and this is what it says, regardless of whether the admitted prior art would otherwise qualify as prior art. So you just included something that may not have been included to make it easier for them to reject your patent. I know a retired IRS agent, and she told me, if you ever get audited by the IRS, keep your mouth shut. Only answer exactly what is asked. She said sometimes people, when she would go in and do an audit, they would say, oh yeah, can I ask you about this part of my tax return? That wasn't part of her audit. Her audit was very specific, but as soon as they put it in front of her, it became part of the audit. And she would say, nope, that's not done right. And now I'm auditing this part too, because they put it in front of her. So it's kind of on the similar basis. If you say that this is what's been done before, and you don't have to use exactly the words prior art to have it be qualified as prior art, or have them deem it as admitted prior art. So what is required in this, in your patent application, in the written description? So you are required to disclose any prior publications that may be relevant to patentability. There's a separate form where you just list them, and you don't have to discuss them. You list them, and then you fulfilled your duty of disclosure. And you don't have to put it in the patent application itself. So the patent office has a list of sections that they recommend that you put in the patent. There's a few that are required, even though you don't have to call them these sections. The required ones that are going to have to be in your patent application are what they call title of the invention, brief description of the several views of the drawings, detailed description of the invention, the claims, and the abstract of the disclosure. So you can have those sections without using the word invention. And then they also recommend, and they say should, but should is not required. So the background section is not mandatory, but it's expected by the patent office. As I mentioned, they like to have you say, this is where we think it should be classified. Here's some guidance on that. So the ones that are suggested is cross-reference to related applications, statements regarding federally sponsored research, the names of the parties to a joint research agreement, incorporation by reference, statement regarding prior disclosures by the inventor or joint inventor, background, which has the field and the description of related art, and a summary of the invention. All of those are optional, and they can be very useful to some degree to the patent examiner, but if they're not written correctly, they can be harmful to your patent application. And so, as I've mentioned several times, we start with the claims when we draft a patent application because that's the heart of your invention. And what So what should you discuss in your background section? First of all, you don't have to have it. You can just do the field of invention to help the patent office. You can also put basically arguments in there by saying the prior technology disclosed does not include this and does not include that. You're really talking about your own invention, even though you're saying, well, the others doesn't include that. It sounds like you're talking about them, but you're really talking about yourself. So that's one of the ways to discuss and kind of make an argument in your patent application. I don't recommend discussing specific prior publications or prior patents that have been published, because that opens the door to the patent office saying, well, you admitted this is prior art, so we don't have to do any more work to show it qualifies as prior art. So make sure you read the patent application before it is filed, and make sure it does not contain any discussion of what others have done, because that's the key. Is if you're discussing what others have done, that's where it's much easier for them to say, you've admitted this is prior art. So it only needs to focus on your solutions. So we encourage you to subscribe to this podcast and listen to the prior episodes if you haven't. For next week, we're going to talk about trademarks and trademark protection to understand what it is that makes a strong trademark, what you can do to possibly strengthen your trademark, and how to protect it properly. And this is a topic that is a lot of clients, a lot of people pick a trademark without considering the strength of the trademark. And we'll talk about that next week. And just as a quick recap, what we covered this week was we covered the importance, all the pieces of what makes a strong utility patent, especially the things that could go wrong. Well, thank you for joining me. I hope to see you next week.
Where are you at as a business in terms of size and scale? I know recently you just had a nice investment from Hertz. So good just to get a flavour for where you